And as a result, the three.
Good afternoon. The court is going to take up the next case on the court docket, C190085CPS. This is in the interest of Andrea Palomares, Maddie Elizabeth Diller, and Valentina J. Diller, children. The case is set for a resumption of a bench trial. The trial is being conducted pursuant to emergency orders of the Texas Supreme Court via Zoom video conference. Participating in the trial today on behalf of the department is caseworker Brendan Ziders and regional attorney Jason Jett. The mother of the children is Maria Isabella Rodriguez Pena, and she is participating in the trial today with her attorney, Jeff Beatty. Let me see. She should be participating. Yeah, okay, there she is. Thank you. The father of the child, the child Andrea Palomares, is Manuel Arturo Palomares Perez. He's been cited by publication through posting. He is not present. There is currently pending before the court a purported affidavit of relinquishment of parental rights by him, and we'll take that up as we proceed with the hearing today. And he is not present. Chris Flores is his attorney ad litem, and Mr. Flores is participating in the hearing today. Vincent Diller is the father of the children Valentina and Maddie, and I believe Mr. Diller should be joining us here shortly from the Montgomery County Jail. I'll ask Ms. Vines to follow up with jail to make sure he gets connected. Ty Grote is the attorney ad litem for the children, and Mr. Grote is participating in the trial today. The CASA guardian ad litem representatives for the children are Maureen Sapezi and Mary Obermiller, both of whom are participating in the hearing today. There's an intervention filed by Dale and Glenda Lindsay, who are the paternal grandparents of the children Maddie Diller and Valentina Diller, and they are both participating in the hearing today, along with their attorney, Gonzalo Rios. Also in attendance at the hearing today are Alicia and David Deering, who are the current foster parents of the child Andrea, and Stephen Charles, who is the current caregiver for the children Maddie and Valentina. It's my recollection that the rule has previously been invoked. I think everybody other than Mr. Charles and Deering would be exempt from the rule. Since we still have further proceedings in this case, I'm going to put them both in the virtual waiting room while we proceed forward. So if y'all will stand by, I'll read y'all over.
Your Honor, also, just for the court's knowledge, my client has appeared.
Yes, sir. Mr. Diller is now in the virtual courtroom as well. The children, if I didn't note earlier, are exempt from or have been excused by the court from participating in the hearing today. Y'all stand by for just a second. I think Mr. Rios stepped away for a second, and then we'll try to resume the hearing. All right, as I noted, we are, this is a continuation of prior proceedings in the bench trial of the three children. My recollection from my docket notes indicate that when we broke, the department had requested to reopen and had been allowed to be reopened to tender to the court for admission into evidence petition exhibit number 3, an affidavit of relinquishment of parental rights purportedly executed by the respondent, Father Manuel Arturo Palomares Perez, as to the child Andrea Palomares. After hearing objections and arguments of counsel at the time, the court recessed the trial and entered an order appointing an interpreter to translate the document that was submitted, that was filed with the court, which was in the Spanish language. The court appointed Maria Caldwell to translate that document, and on July 14, 2021, her translated version of that document was filed with the court, along with her affidavit reflecting the accuracy of that translation. The order appointing the interpreter also provided for any first party wishing to object to the accuracy of the translation to file prior to the resumption of the trial today. Any objections to that translation, specifying any inaccuracies in the translation and offering an accurate translation if they had objections to it. In reviewing the court file, I did not find any written objections to the accuracy of that translation file with the court or any proposed alternate translations of the document. With that, I'm going to ask our department, is the department ready to proceed today, Mr. Jett?
Yes, Your Honor, we're ready to proceed. Just a few minutes ago, I emailed to Mr. Rios, Ms. Zapisi, Mr. Graves, Mr. Betty, Mr. Grote, Mr. Flores, Ms. Vines, and Ms. Drake, what I labeled as Petitioner's Exhibit 4, which is a copy of the Spanish language affidavit, a translation, and a certification of the translation. And those are all certified copies. I emailed that to everyone. So pending everyone's receipt of that, yes, Your Honor, we're ready to proceed.
Okay, so you're saying you basically forwarded to them what was filed by the interpreter on July 14th as being a certified copy of that document, the affidavit of the translated affidavit of voluntary relinquishment and the affidavit of the interpreter.
Yes, Your Honor, with the file sticker and again a certified copy. Yes, that's correct.
Okay. As I go through and ask for announcements of readiness to proceed, I'll also ask if the attorneys could verify whether or not they have received that at this point. I'll start next with Mr. Beatty. Mr. Beatty, are you ready to proceed?
Yes, Your Honor, I'm ready, and I did receive.
Okay, and Mr. Graves?
Ready, Your Honor. However, the one I received was encrypted, but I may be able to get that somehow figured out.
Your Honor, I have no control over that. It's a problem statewide with IT, and my apologies for it, but I have no way to, I have no control over that.
Mr. Flores?
Ready, Your Honor.
And did you receive the exhibit? Mr. Flores, did you receive the exhibit?
Yes, I'm confirming that, Your Honor.
Okay, thank you. All right, Mr. Grote.
I'm ready, Your Honor, and I did receive the exhibit.
Okay, and Mr. Rios.
Yes, Your Honor, we're ready, and I did receive it.
Well, I guess if it's encrypted, Mr. Graves, you may need some time to see if you can address that. I believe you have to have a password to access.
Your Honor, I've while we've been waiting, I've managed to pull it up with a brief password. So I think we're good.
Okay.
I'm ready to proceed.
All right, thank you. And thank you.
No,
No?
I'm cold, but.
Okay, all right, Mr. Jett, as I noted, I'm sorry. Mr. Jez, I noted, I believe we were at the point where the department had proposed to tender this. So is the department asking to withdraw? I think originally this was proposed as petitioner's exhibit number 3. Are y'all withdrawing that tender and offering petitioner exhibit number 4?
Yes, Your Honor.
Okay. All right. Is there any objection to the court admitting in evidence petitioner's exhibit number 4?
No objection.
No objection.
No objection, Your Honor.
All right. The court, hearing no objection, will admit into evidence petitioner exhibit number 4. All right. Thank you. All right. Mr. Jett, I believe you had asked to reopen for that limited purpose. Or any other evidence you wish to tender to the court at this point?
No, Your Honor. Thank you.
Okay, so the department's now rested. Thank you. Let me just go through the attorneys one at a time, make sure there's no other matters before we get to closing arguments. Mr. Beatty, any additional evidence you wish to present?
No, Your Honor, no evidence.
Okay, Mr. Flores?
No witnesses, Your Honor, and with the admittance of the state's new exhibit, with the relinquishment, I would ask that I'd be excused from the remainder of this hearing.
All right. You'll stand by for just a minute. I'll come back to that in just a second. Let me get the announcements for everybody else. All right. Let's see, Mr. Graves.
Nothing further, Judge.
Okay, thank you. Mr. Grote.
I have nothing further, assuming no one else decides to reopen, Judge.
Okay, thank you. And Mr. Rios.
Nothing further, Your Honor.
Okay, thank you. All right, the court, after noting that petitioner exhibit number 4 has been admitted into evidence, which is an affidavit of voluntary relinquishment of parental rights executed by Manuel Perez, indicating he has knowingly and voluntarily executed his affidavit of relinquishment, the affidavit of relinquishment of parental rights, relinquishing his parental rights to the child Andrea Palomares, finds good and sufficient cause to discharge Christopher Flores as his attorney ad litem for purposes of any further proceedings in this case. So, Mr. Flores, I will discharge you effectively immediately as his attorney ad litem, and you are free to leave the virtual courtroom at this point.
Thank you, Your Honor.
All right, thank you. All right, I believe we should be down to closing arguments. So, and Mr. Jez, the department reserving its closing.
As it's become predictable, Your Honor, yes.
Okay. Thank you. All right, Mr. Beatty, I'm going to go to you next and for any closing arguments you have relating to the case. Thank you.
Judge, we'd just tell the court that we'd like the placement to stay the same. We do not believe that it's in the best interest of the children to be placed with the grandparent.
Okay, I'm sorry, I garbled a little bit. My understanding, you want the placement to stay the same, and your client is not supporting the grandparents having custody of the 2 children they are seeking. Is that right?
Correct, Judge.
And regarding the termination as to Andrea, I believe there was a relinquishment she had filed, and she's not objecting to that, as I understand.
No objection.
Okay, thank you. All right. Let's see, Mr. Flores is gone. Mr. Graves, any closing?
Your Honor, we stand, Mr. Deller and I stand upon the relinquishment that we previously admitted into evidence in this case. As far as the placement of the children are concerned, Mr. Deller is in step with the Lindsays, and our request is that the children, other than Andrea, we have no objection to the termination of rights in Andrea's case. That's not my client's case. However, as to the other 2 children, we are asking the court, based upon the evidence and the testimony that you've heard from the Lindsays, from Ms. Charles, from everyone involved in this case, that those children be placed with their blood relatives, the Lindsays.
All right, thank you. All right, Mr. Rios, I'm gonna go to you next. Your closing statement and arguments.
Yes, sir. Thank you, Judge. May it please support all counsel that are present. Judge, first and foremost, I do want to inform the court, my client's position is that they want what's in the children's best interest. That's the reason they got involved from the very beginning, because they want what's best for these children. That being said, they are asking to be named joint managing consortiums with them having the primary right to establish the domicile of the two younger children. I don't want to regurgitate everything, Judge, or review it, go over everything. You've heard a lot of evidence. This has been going on for a long time, but I do want to hit some highlights about what we think that the evidence has presented to you. We go back in 2019, my clients, the Lindsays, were rocking along being typical grandparents. Typical grandparents loving all their grandkids, involved as much as they could in all their grandkids' lives. It's important to note my clients had never had any CPS involvement, had never had any criminal involvement, ever whatsoever. And these are individuals that are in their 50s, people that have lived their whole life being law-abiding and taking care of the people that they are supposed to take care of. That is the background that we had, Judge, when we got into this situation. And one day they're presented with this dilemma where Mrs. Lindsay's son and daughter-in-law have been abusing these children, have been abusing them to the level of abuse that has not been seen hardly ever in our system. And they're presented with the fact that they want somebody to take these children and take care of them immediately, not next week, not next month, not in 6 months, immediately in the condition they're in, and provide a place for them to live, the love and the structure and the discipline, all the things that come from being a parent. So they were asked to switch from being grandparents, turn that switch off and turn on the switch of being now parents of their grandchildren. I would submit to the court that none of us, no one involved in this case had any inkling or idea what the Lindsays were getting into. And certainly the Lindsays did not. And there's no way that anyone could have known what they were getting into. No one envisioned the task that they were going to have to perform every day for the next 2 or 3 months to take care of these children. It is undisputed, Judge, that my clients, in spite of that, kept every appointment, made all the appointments, make sure that the kids got to the appointments, put the kids in school, did all the things that they had to do physically to make sure that these kids were at least in an environment that was starting to be stable, starting to be disciplined, starting to be where they had a curriculum, they had an expectation of what was expected of them. That was what they did. It's undisputed, Judge. Even CPS caseworkers, CASA, all of them agreed. In fact, they were all on board saying, you need to come and you need to do this because they need to. And in the background, Judge, these are people that, again, have always stepped up and done what they're supposed to do in the whole time that they've been on this earth. We rock along, Judge, all of a sudden, there's an accusation or two that are made about 2 or 3 months after they've had these children. Never mind that we're not going to tell the parents. Never mind that we're not going to tell the Lindsays anything. We're not going to tell the Lindsays anything. We're not going to tell their attorney anything. We're just not going to return the children. I would ask the court to put yourself in their position. They're grandparents that have always been there for these kids, that are now being parents, that are now doing everything every single day of the week to care for these kids. And all of a sudden, these kids are not brought back to them. And they have questions, which CPS never answered for them. Never told them, we need to have a discussion. We need to have a meeting to discuss what these children are saying. You know who is the one that requested a meeting with CPS? We did. We did when we saw that these tasks were pretty heavy. They're pretty involved. We requested a hearing with CPS and we met with them at their offices and we told them all the concerns that we had. It was very difficult to keep all the appointments. The kids were still acting out. There were being a problem. Andrew was running away. All of that was put on the table for them at their office on one occasion by all of us. And on top of that, my clients constantly had contact with CPS to let them know what was going on, to let them know what the appointments were, to let them know how the kids were doing. Everything they did, I would submit to the court, is what they should have done, and they did it, and they did it the right way. Now we're here, and all of a sudden, it goes from my clients being the ones that have rescued these children and provided the things that they need, to now being on the outside looking in. Beginning, I would say November, October 2019, on the outside looking in. All of a sudden, they're nobody. They can have no contact. They don't even know why. There's nothing there that they can do about it because we keep being told, we're investigating, we're investigating, we're investigating. And under the law, they had 45 days to investigate. It didn't get done. We didn't get any answers till well over 7, 8, 9, 10 months later about what the allegations were. And even then, they were addressed like they were true. True from a child that had already made an allegation prior to that day about another sibling that was completely false. True about those types of children that were so abused, that they were so confused, that they were going to do whatever they had to do to just get their way. All that was discarded when it came to my clients. All that was put aside. All their history was put aside. The fact that they had done each and everything that they were asked to do, all that was put aside. Eventually, they put up with Mr. Charles. Mr. Charles does the home study, Judge. Does it say that he had CPS involvement before? No. Does it say that he had a protective order entered against him where a district court judge found that he committed family violence? No. Does it say that he had an assaultive history? No. And yet that's the home study that they used to glowingly say this is the appropriate place to put these children. And then when they find out later, they said, well, we're not concerned about it. When we did find out, which was after we put the children there, we weren't concerned about it. They're doing fine. Everything's going fine. This is the situation as it exists. Even at the hearing here, it's a home that's crowded. This gentleman is probably on his 4th relationship. He has all that history. He has that protective order has been found against him. And yet, everybody seems to say it's not a big deal. I would submit to the court that we've had other cases where that has been brought out about prospective foster parents, family. And CPS's position is, oh, they don't qualify. You can never have a protective order filed against you where they found that you committed family violence. Those things are red flags. What if they testify? Oh, they're no big deal. They're no big deal. Yet my clients have none of that. None of that. They had an allegation from a child that had already said something that was not true, that was egregious about what he said. And it was found to be not true. And yet that's all they used to basically put kick my clients to the curb and say you're no longer a viable option. But we're asking the court to make that right. We're asking the court that my clients be primary on the young children. My clients took care of all 4 of them. These are 2 children. We're asking the court that if that's not what the court wants to do, that they have specific visitation, standard visitation with his children. There's no reason why they can't. There's no reason why they shouldn't. They are family. You've heard testimony about the fact that it has been difficult to have any contact with those children while they've been with Mr. Charles. He gets up there and says, well, if all they'll do is call. My clients have called. My clients have called. I've called CPS. I've left messages telling them, can we work out something? I have gotten no response. And so if that's the way it's going to move forward, then these children are never going to be part of this family. Before this incident happened, this family was pretty tight. They all got along. They all got together for events that they had in the family. It has started to get that way with the older children already. We heard testimony about that also, that they were at get-togethers from the last hearing that we had. That's what needs to happen, Your Honor. It's going to take a village to raise these children, because the parents, unfortunately, are probably going to go to prison for a while, and they're not going to be around. And even though they're terminated, they're still parents, but they're not going to be around. It's going to take a group of family members to raise these children and to make sure that they're there when they need things. And so that's what we think is in the best interest of the children. Thank you.
All right, thank you, Mr. Rios. See, Mr. Grote, any closing?
Thank you, Judge. Mr. Rios is correct that the grandparents did step up. Mr. and Miss Lindsay did step up and take placement of these children after this horrendous abuse that occurred in the home at the hands of their parents. However, when they took possession of the children, the two children at issue were very young at the time, and had very little contact with the Lindsays at least the last 2 years leading up to this case, due to the fact that the family was basically, the parents of the children were keeping the Lindsays out as well. So we're talking about two very young children who come into Lindsay's home. Unlike the two older children, Teresa and Andrew, they did not know the Lindsays. They did spend some time in the Lindsay home, about 2 months. At this point, they've been in the home that they've been placed in for the last 1.5 years. And they remain in that home. That home plans on adopting them. And as far as I know, there are absolutely no barriers to them adopting these children. The children started making outcries to the department and to the ad litem's very early on in the case. There was a lot of inappropriate stuff going on inside the home. The grandmother was spanking the children. That was reported on multiple occasions by the children. It was reported in the home study. The department, the ad litem's, and the home study examiner all had a discussion with Miss Lindsay about the spanking, and it still continued. We still kept getting reports of it. I'm not sure what else we were supposed to do other than remove the children, especially in light of the fact that new allegations came out from Teresa and Andrew regarding them withholding hygiene products and things of that nature. We've also got testimony in the record regarding Teresa in particular, who suffered the worst of the abuse in the home of her parents. She had been basically socially isolated for several years, had not been in school, had not really had any contact with family or friends. Everyone in the case thought that it would be very good for Teresa to be able to participate in some social activities, to be around some friends, to participate in school and extracurricular activities. Miss Lindsay removed Teresa from her volleyball team over the objections of the ad litem's and the departments. She was specifically told that that was good for Teresa, and it was done because she was behind on her grades at school. Of course she was behind on her grades at school. She'd been at home not attending school for the past 2 years. It was going to take some time to catch up, but everyone thought that her social interaction was more important than her grades at that time. Yet Miss Lindsay took it upon herself to decide that that was not what was appropriate for the child, and she removed her from volleyball. These are problems that had to be addressed. Okay, we attempted to address them with Miss Lindsay. We attempted to address them with Miss Lindsay and her attorney in multiple meetings. They never got addressed.
Your Honor, that is totally being false about saying it with me and my client on multiple occasions. That is not true.
I'm gonna sustain it to the extent I don't recall. I could be mistaken, but I don't recall any specific evidence about the exact discussions at these multiple meetings. So
I apologize. There was evidence of a meeting held in the jury room after I believe it was after the status hearing. And Mr. Rios and both parties were present to that meeting.
All right, you can proceed.
Thank you, Judge. Again, we could not get these issues fixed, and we did not feel that it was appropriate to leave the children in the home considering these issues were occurring. We removed the children. We first placed them with Crystal Charles, family member and daughter. Mrs. Charles could not handle the children. She turned them back over to the department. So we've tried to keep these children in this family, Judge, and it didn't happen. We also looked in there, I believe there were 10 siblings, 9 or 10 different siblings of Mr. Deller, the father, paternal siblings, which would be related to Miss Lindsay as well, that would allow to keep them in the family. I believe that the department and CASA contacted every one of those children, and none of them would agree to be placement for these kids. At that point, we were forced to look outside of the Lindsay family. Mr. and Miss Charles agreed to take the children, and we placed them there. The CPS involvement that Mr. Rios mentions involving Mr. Charles, I don't believe there's any evidence in the record of that. There were no CPS documents submitted to show that there was a case. I believe it was just his allegation that there was one.
And Judge, I would object to the fact that Mr. Charles himself testified that there was a CPS history, that there was a protective order entered against him. That's evidence. His own admission.
Well, I'll review the record and see what evidence is there, but I believe there was some discussion of at least a protective order, if not CPS history. But I'm going to obviously make my decision on what's in the record, but go ahead, Mr. Grote.
Thank you, Judge. And I can say the same for the history of assault. I don't believe there was any police report ever submitted, though there was possibly some testimony regarding that. And as far as the claim that the allegations made by the children in this home were unfounded and just allegations, they were not unfounded. They were not just allegations. There was a CPS investigation. It was a very long investigation, yes, but there was an investigation. And there was an RTB finding that was the outcome of that investigation.
Your Honor, I would object that that is being appealed and is not a final RTB at this point.
Judge, at this point, there's still an RTB associated with this case.
That's not what the procedure said. The procedure said if you appeal it, it's not an RTB until you have that hearing.
There's been no evidence that's under appeal, Your Honor.
We've testified, my clients have testified that it's under appeal.
I believe they testified it was under appeal. Well, I'll reserve a ruling on, I'll evaluate that and take a look at whether I can consider that if there's evidence of it in the record. My recollection is that there was some testimony about there being an RTB and that the Lindsays were seeking to appeal it. So whether or not it can be considered, I'll review that.
Thank you, Judge. But at the end of the day, these children have been in their current home for a year and a half. It's really the only home they know at this point. I think that to rip these two children out of this home and put them back in the Lindsays at this point there's no way that's in the best interest of these children. Especially when we consider the fact that we could have resolved all of this at a placement hearing early on in this case. The placement hearing never happened. The department removed their objection to the Lindsays having contact with the children, and the request for a hearing was dropped by the Lindsays. That's why these children have been in this home for a year and a half at this point. Now, a year and a half later, they want to come back and say, well, we don't think this was appropriate to put them in Mr. Charles's home and we want them returned now. Well, at this point, they've been there for a year and a half and that's their home. And I think to remove them at this point would be extremely detrimental to those children. Not to mention the fact that we've never had an issue with the children in the current placement with the Charleses. They've been there for a year and a half and no one has ever had any issue whatsoever. Not one problem has come up in this case involving that household. The current caregivers plan to adopt these two little girls. As far as I know, the only reason there's not a petition for adoption is because we're in a CPS case. And if you look at the Texas Family Code, section 153.434, that puts a limit on grandparental access to children. I know it does not specifically apply to this case, but the policy decision made by our legislature.
I'm going to object that what he's arguing is irrelevant. If he says it doesn't apply to this case, it's irrelevant.
I'm arguing a policy decision, Judge, a policy decision that's clear from.
Okay, let me roll an objection first. I think I'll consider the argument, and then you can make another objection after the end of it. I need to hear why that particular provision would be relevant to any decision made in this case before I can rule on the objection. So I ask you to address that as part of your argument, and then I'll consider any objection by Mr. Rios.
Thank you, Judge. I'm saying that section has an application to this case because what it does is it requires, it limits a grandparent's access to a child when there's an affidavit of voluntary relinquishment from both parents, and the grandchild has either been adopted or is a subject of a pending suit for adoption. The children have not been adopted, nor is there a pending suit for adoption. I understand that. However, there is a planned adoption here. Mr. and Ms. Charles have expressed their willingness and desire to adopt these little girls. They have gone through the licensing process. From what I understand, everything has been completed. We are simply waiting for this case to wrap up. And then there will be an adoption proceeding. I'm arguing that that's got relevance to this case because our legislature has seen fit to restrict a grandparent's access to children in that sort of situation because in that situation.
And I apologize for interrupting as well, but I'm going to object at this time too, because just from Mr. Grotzon's statement, that has not been filed. Just because a plan is in place doesn't mean that it's been filed. I don't think that's a relevant argument at this time.
I'm going to sustain the objection as to that, but I will note while that statute is not, I think, applicable based on the facts or relevant based on the facts of this case, under the Texas Family Code and under existing case law, the plans for the child by the caregivers is a relevant factor for the court to consider. So while that statute in and of itself, I don't believe is currently applicable because there's not a pending adoption suit, the plans of the potential caregivers for a child, including the department or any parent or foster parent, is a factor the court consider in determining best interest. So I will consider any plans of that nature in making a determination in the case.
Your Honor, then I'm going to object on the grounds that there's no evidence that was presented that there was going to be an adoption. He's making that blank statement. There's no evidence. We're arguing what the evidence showed. We're doing a survey of the evidence. His evidence shows nothing. Nobody has testified we're going to adopt these children.
There was evidence, Your Honor.
There was evidence, Judge. Mr. Charles testified to that.
Well, I'm going to reserve judgment on that ruling, Mr. Rios. I would have to go back and check. I'm not disputing you, and I'm not giving credence what Mr. Jett or Mr. Grote said at this point. No offense to anyone involved, but this has, as y'all noted, has spread over a period of time. Unfortunately, I didn't have time to go back and read through my notes. I seem to recall some testimony about that being admitted into evidence, but I don't know that for a fact. So I'm going to reserve judgment about ruling on your objection on that, and I'll just have to review the evidence. I'm obviously going to go with what is in the evidence in the case. This is argument at this point. It's not evidence.
Right, good. And I apologize if I am going outside the evidence, but I'm kind of in the same situation as you. As this was stretched out over a very long period of time, I have a very difficult time recalling exactly what was discussed and what wasn't.
No, I can assure you, I'm going to go back through and all the evidence, and I'm going to try to make my decision based only on what was admitted into evidence. But I'll certainly consider the objection that was made by Mr. Graves and Mr. Rios relating to that potentially being outside the scope of the evidence that was presented. Thank you.
May I continue?
Yes, sir.
Thank you, Judge. The point I'm trying to make is the fact that if the Lindsays are granted possession rights of these children and given some court-ordered, set in stone possession to these children, we're setting up a situation where an adoptive parent is now forced to give up possession of their child to someone who's not a family member. And that creates a problem, I think, especially considering this case where Mr. Charles was once a member of the Lindsay family. I would assume that there's some bad blood there. There's always a possibility of bad blood when you talk about a divorced family member. And so we're setting up an environment that's likely to create problems for the children, okay? And the problems for the children are what we're looking at to avoid here. We're looking at their best interest, not the best interest of the grandparents. And I don't believe that it would be in the best interest to either give conservatorship to these grandparents, to either name them as a joint managed conservator or a possessory conservator. Mr. Charles was once a member of this family. He does still have children in this family. He will be around. He has been around, and he did testify to that. The Lindsays have seen these children since they were placed with Mr. Charles. At family events, they will continue to see them at family events. And I believe the testimony also showed that even after the department removed its objection to the Lindsays having contact with the children, I don't believe there was any contact after that, short of a few encounters at family gatherings. So I don't believe that they had reached out, as I believe what Mr. Charles had testified to. So in this situation, I don't think that it would be prudent or in the best interest of these children to give any sort of conservatorship rights to these grandparents. The department made all the efforts it was required to make with regards to placing with these grandparents, and they tried to place with another child of these grandparents. And then they looked into every other child of these grandparents to try and find a placement within this family, and we could not find one. Now they've got a stable placement where they are safe. They are very well taken care of. There are no issues in that home at this time. And to interrupt that, to throw a wrinkle into that could potentially create problems in the future, I think would be imprudent. And I believe that's all I have, Judge.
Thank you. All right, Mr. Jett.
Thank you, Your Honor. I distinctly remember when this case started. And it was at that point that I thought that I had started writing my closing argument, even before I knew what was going to pan out. And I thought I was going to be here for a long time today talking about this case and giving you my closing argument. But it comes down to this. I don't have a lot to say about this case. Mr. Grote said this was one of the worst cases of abuse many of us have ever seen. I think Mr. Rios said that as well. They're both right. It is. And I think we're all very lucky that we didn't have to go through event by event what brought us into this case. This is a hard case. It's been a difficult case on all of us. I suspect that there's not one of us that's in this courtroom today or been in this courtroom that didn't shed a tear or 100 about this. The upside of this case, the silver lining, is that what we're fighting about today is the best interest of these kids, because we've got multiple fronts asking for these kids. So that is a good thing. In my line of work, is my job as the department's representative, that's positive. Judge, we're asking you to accept the relinquishments of all three parents. They made mature, responsible decisions, and the best decisions they could make for their children. Mr. Palomares, Mr. Deller, Mrs. Peña-Del. Absolute right decisions right there. We tried lots of places for these kids, and they've been the two younger kids. And here I go again doing what frustrates me about this case, and that's that we're not talking about Andrea, except that Andrea found her permanency a long time ago. And that's one of the reasons we don't talk about her nearly as much, is because we've known from really early on that she was going to the Deerings and she was going to stay at the Deerings. Thank you to the Deerings for being that rock, for being that stability for her, for them, for us through this case, so that we didn't have another piece we had to solve. That piece solved itself. That family clicked. So I'm going to start there with thank yous again, and ask you to terminate the rights for Andrea so that she can be adopted before she's 18 by the Deerings, because it's really clear that they love her. And that makes a good outcome in my world, in our world. For those of us who play in the CPS sandbox on a regular basis, that's about as good as it gets. The little kids, the two younger ones. Judge, as hard as this case had been, I don't think the decision is that hard. These kids have been in this home for over a year and a half. Please leave them there. Do not move them.
Phone caller.
Grandparents' rights are subject to parental rights. Judge, I'm asking you to terminate the rights of the parents today by their request, and to terminate the rights of the grandparents through that. We all know that the court making a decision about terminating somebody's rights doesn't terminate a family always, because those people are around. They know who the grandparents are. They're going to be around, especially in this home that they're in now, which has half siblings and therefore other grandparents. Mr. Rios talked about his clients. Judge, I'm not going to vilify his clients any more than they've already done it to themselves. But let them be grandparents. Grandparents. They call, they ask, they get yeses, they get nos, they get, let's go get ice cream, let's go to the mall, let's go to Walmart, whatever, not you get X visitation on Y days. No, that's not what grandparents do. Mr. Rios said they want to be grandparents. Well, then by golly, let them be grandparents. And grandparents in my house and in many people's houses don't have a set time of visitation. Therefore, these grandparents, let them be grandparents, and they don't get times of visitation. Let them call, let them ask, let them come to the birthday parties, let them come have cake and ice cream, let them go to the ball games, the dance recitals, and whatever else it is, like grandparents do. They don't want to be the parents, don't ask them to be the parents. Ask them to be grandparents and participate in their grandchildren's lives in the manner that grandparents participate in their lives. Allow these children to be freed up for adoption to the Charleses and live in the home where they live with their siblings. Thank you, Judge.
All right, thank you. Well, I appreciate everybody's time and efforts in this case. Cases went on for quite some time, and I do not want to make it go on further than I have to, but it's going to take me a little bit to go back through the evidence and then render a decision in the case relating to Mary and Valentina. I am going to do something a little bit unusual as it relates to Andrea, however, since her case, there's affidavits of relinquishments by her parents. Doesn't seem to be any real contest about her situation. I'm going to take under advisement the actions relating to Maddie and Valentina, but I'm going to enter an interlocutory order relating to Andrea, and then I'm going to sever that action out so it'll be a final order so that time period for her case can be going forward. So I'll take, as I indicated, I'm going to take the case relating the actions, relating to Maddie and Valentina under advisement, and the fellow stand by for just a moment. Okay, the court, in connection with the action relating to the child Andrea Palomares and her parents Maria Isabella Rodriguez Pena and Manuel Arturo Palomares Perez, is going to present to the provisions of Chapter 201 in the Texas Family Code after hearing the evidence presented in the case and after taking judicial notice of the court's file to the extent permitted by law as it relates to that child and those respondents. And after considering the...
I'm sorry to interrupt you, but I think Ms. Deering is in the waiting room, and I know that you're making your announcement, but I didn't know if you wanted to bring her in for this.
Okay, thank you.
I do apologize for interrupting, Your Honor. I know it's bad form.
The court will know for the record that the court has brought back into the courtroom, the virtual courtroom, Alicia Deering and Mr. Charles. The court is in the process of making this ruling. The court is going to take the matters relating to Maddie and Valentina under advisement. As it relates to Andrea, the court is going to enter an interlocutory order and then make it a final order. If y'all stand by for a minute.
Yes, sir.
As I indicated before, the court is presented Chapter 201 of the Texas Family Code after hearing the evidence presented and the recommendations of the attorney ad litem and guardian ad litem in the case as it relates to Andrea Palomares. Going to enter the following findings and enter the following orders as to her on an interlocutory basis as to Andrea Palomares. Court finds that a request for identification of a court of continuing jurisdiction has been made as required by law, and that no other court has continuing exclusive jurisdiction of that child, and this court has jurisdiction over this action relating to Andrea Palomares. Court finds that all parties entitled to notice have been notified. Court finds there's been a material and substantial change of circumstances of the respondent Maria Isabella Rodriguez Pena and Manuel Arturo Palomares Perez since rendition of any prior orders relating to the child Andrea Palomares, and it would be in the best interest of that child for the court to modify those prior orders. The court finds any presumption that the respondent Maria Isabella Rodriguez Pena or Manuel Arturo Palomares Perez should be appointed as a managing conservator or as a possessory conservator of Andrea Palomares is rebutted. The court finds that the appointment of either of those respondents as a managing conservator or as a possessory conservator of that child would not be in the best interest of the child because such appointment would significantly impair the child's physical health and emotional development. As to the respondent Maria Isabella Rodriguez Pena and the respondent Manuel Arturo Palomares Perez and the child Andrea Palomares, the court finds that The respondent mother and Mr. Perez have each knowingly and, finds by clear and convincing evidence that each of them had knowingly and voluntarily executed after the suit was filed an affidavit of voluntary relinquishment of parental rights to the Texas Department of Family and Protective Services pursuant to sections 161.001B1K and section 161.103 Texas Family Code, relinquishing their parental rights to that child. Court further finds by clear and convincing evidence as to the respondent mother Maria Isabel Rodriguez Pena and the father Emmanuel Arturo Palomares Perez and the child Andrea Palomares that it would be in the best interest of that child for the respondent's parental rights to be terminated pursuant to the foregoing sections in section 161.002B2 Texas Family Code. Court finds by clear and convincing evidence that the court's findings under section 161.001B Texas Family Code and the order of termination of the respondent's parental rights is not based on evidence precluded from consideration by the court under section 161.001C Texas Family Code. Court finds it would not be in the best interest of the child to appoint a relative or other person as a managing conservator of the child, Andrea Palomares, and that would be in the best interest of the child to appoint the department as permanent managing conservator of the child and to continue the child in the current placement pending further order of the court. The court finds by clear and convincing evidence that the following orders are in the best interest of the child, Andrea Palomares. It's therefore ordered and decreed that the parental rights of Maria Isabel Rodriguez Pena to the child, Andrea Palomares, is terminated. The parental rights of the respondent, Manuel Arturo Palomares Perez, to the child, Andrea Palomares, is terminated. The department is appointed as permanent managing conservator of the child with all the rights and duties of a non-parent managing conservator under Texas law. Current placement of the child is approved pending further order of the court. The court will continue tag rote and CASA as the CASA guardian ad litem and attorney ad litem for Andrea Palomares pending further order of the court. The court will set a permanency hearing after final orders on a date to be announced 90 days after the entry of the order of termination. The court gives notice to the parties and counsel the right to appeal the court's findings in order pursuant to section 263.405 Texas Family Code and of the right to request a de novo hearing before the referring district court pursuant to section 201.015 Texas Family Code. The court gives notice that an appeal in a suit in which termination of the parent-child relationship is sought is governed by the procedures for accelerated appeals in civil cases and the Texas Rules of Appellate Procedure, and that a failure to follow the Texas Rules of Appellate Procedure for accelerated appeals may result in dismissal of the appeal. The court, based on the interlocutory order terminating parental rights of the child Andrea Palomares, will enter an order severing that action from the actions relating to Maddie Diller and Valentina Diller and assign to it cause number C190085CPS-1. Mr. Jett, I'm going to ask the department to prepare an interlocutory order of termination of the parents' parental rights based on the court's orders and order of severance, and then an order that makes the interlocutory order a final order and submit all three of those documents to the court. I know it's a little bit of unusual procedure, but I believe in your hot docs forms there's a protocol for doing that. And so I'd ask you to submit those documents so that we can have that action finalized. As to Maddie and Valentina, as I indicated before, I'll take that matter under advisement and I'll get a decision out as quickly as I can to the attorneys in the case and let you know the court's ruling. And I'll start with the department, Mr. Jett. Any other matters we need to address for today?
No, Your Honor, thank you.
Hey, Mr. Graves, any other matters?
No, sir.
Mr. Beatty?
No, Your Honor, thank you.
I think Mr. Rios, anything else? No. Thank you. And Mr. Rote?
Nothing else, Your Honor.
All right. Again, thank you. Sorry this is taking so long, and I'll try to get this resolved as quickly as I can. Thank you.